So we're going to now go to Sue England. She's from UK, Germany. She's a human rights law specialist, worked in a number of countries, UK, Belgium, and Germany. She's very keen to ensure we understand our rights. So she runs courses in human rights law for non-lawyers, which many of us have been to and can highly recommend. They're just fantastic. Loads of people are putting in the chat what great series they are. So, and we'll share them when you get started again on them. The title of Sue England's talk today is Outline of the UK Human Rights Act and its connection to the European Convention on Fundamental Rights and Freedoms. So thank you so much for speaking, Sue, and over to you.
I've done a lot of sessions and they will start again, but I have this spring, but I haven't got a date yet, but it's nice to be here. I was asked to do a couple of sessions. I'm going to do something this week and something next week. And I'm going to keep it short, and I don't have PowerPoint slides. So this is about just a refresher and also bringing us up to date. It's mainly focused on the UK, I'm afraid, about how these mysterious things, our human rights, work in the UK. Because there was a big hoo-ha about human rights in the UK in 1998. And if you think about that, that's 26 years ago. And many people just won't have been, involved at that stage, or may now be a bit fuzzy about the details. But what we had in 1998, courtesy of the Labour Party, in fact, under Blair, was a bringing of rights home to the UK. Now, what did that mean? That was because Britain, like all the other European countries in the Council of Europe, had signed up to this wonderful European Convention on Fundamental Rights and Freedoms, which is usually just called the European Convention on Human Rights. So you can use the shorter title. But we didn't really, that was 1950, and we didn't really have full access to it. This was, the powers that be fiddling about, because we were fully signed up to the European Convention on Human Rights, but you couldn't use them in British courts. You had to, if you had a problem, you had to go through the British court system and all the appeals and things like that. And they weren't allowed to discuss the European Convention rights. And what you had to do was stagger through this long process of going to every court, making appeals and things. And if you weren't happy with the results, you could then apply to Strasbourg and go to the European Convention Court in Strasbourg and get a decision there. This was called exhausting your rights, and it was a very good term because it exhausted you. It could take 7 years to do this and finally get up to Strasbourg and say, well, by the way, this case ought to be decided on the basis of my human rights. Now, this was annoying our bosses, the government, because then what happened was loads of cases were being taken to Strasbourg from the United Kingdom. And the figures looked terrible. If you were in Spain, you were using the European Court of you were using the European Convention in your courts. So you were sort of shuffling it, it was being dealt with, and you didn't have to go onto the public stage. So the UK looked as if it had an absolutely awful human rights record because all these cases were being taken to Strasbourg because they weren't dealt with back in the UK. So the Human Rights Act came in and brought these rights home, as they say. And ever since then, you can plead any of the rights you have under the European Convention in your courts, in your local courts. If they don't come to the decision that you like and you're still not happy, you can still then appeal to Strasbourg and get a decision. But this is why there has been this huge upswelling of human rights issues being discussed in the UK and argued about in our courts. And as we're all aware, we've been doing an awful lot of lawfare because of this as well, because we're trying to bring in these essential human rights that we have. So the Human Rights Act gives us these rights, which are from the European Convention, and everybody in Europe has. And so let's just briefly mention some of them, because I mean, I'm not going to do a laundry list talk, but obviously you have the right to life, but that can be very important if you are getting treated very badly in prisons or by the police or in hospitals. You have a right not to be tortured or subject to inhumane or degrading treatment. And these rights are needing to be used more and more by women as they're suffering bad treatment from the police or suffering bad treatment in hospitals, for example. Torture doesn't have to take place, in prisons. Children have the right to an education. That's very important. All of us have the right to be treated fairly if we go to court, either because we're being charged with criminal offences or because we're going to the civil courts. We have the right to fair procedures throughout those processes. We have the right to vote. We have the right to respect for our family and private life, and that has been very important and used in many ways. And also, we have these crucial rights. Here is where we have these rights to freedom of thought, freedom to hold our own ideas, whatever type of ideas there are. People talk about, it's called beliefs, but just translate that into ideas. We have the right to freedom of expression, or freedom of speech, as it's more familiarly known. And of course, we all know that there have been loads and loads of cases about this and continue to be cases about this, because your freedom of speech can't be shut down unless you are actively inciting real violence against other people. By which I mean, you're saying our organisation should go out and kill people. Not this false, oh, I'm feeling frightened of you because you're saying things that I don't like and are not very favourable towards my group. No, has that person actually said we should collect money and get weapons and we should kill people, an individual person or in some group? And also, freedom of expression can only be shut down if you're talking about actively destroying the human rights of other people that are set out in the convention, actively destroying them, saying, we don't want democracy anymore. We don't want women to be given the same rights as men. We don't want Black people to be given the same rights as groups with other coloured skins. I mean, you've got to be fighting against the basic principles of democracy and non-discrimination and fairness. And then finally, we have what's called the right of association. Well, it's not final, okay? It's my final one I'm going to mention. There are others, okay? Which we are associating here. We're associating on Zoom. We're associating when we have other forms of connection with people. We're associating when we take part in all sorts of groups and exchange information between ourselves, even if we're not in the same room. It's an old term because, of course, in the past, people actually usually had to physically meet. We couldn't do this long distance using this technology. So these are all rights which we are extensively using, and it's very important that we continue to do so. Another thing is a particular element of this particular system between the Human Rights Act bringing these rights home into the UK. When they were, Labour did this in 1989, and shortly afterwards, they did devolution. They did some regionalism of the powers to make legislation and control things in the UK. And they did that for Scotland, Wales, and Northern Ireland. So to keep it a bit simple, we have sort of 3 provincial governments now that can make laws going through their own parliaments and also enforce those laws. They run their own police forces and things like that, okay? So one of the very important things about this situation was that the arrangement was made that those parliaments and governments in those 3 places cannot do anything which is against human rights. Anything they try to do which doesn't comply with human rights is void. It's not valid. It never becomes law. Now, the legal peculiarities of all this are that Westminster still can do things that are against human rights. And that's a complicated situation, which I'm not going to plunge into now because it takes quite a long time to explain. But we do have this strange situation that anything that they do in Scotland, Wales, or Northern Ireland they can't do anything unless it's in compliance with the European Convention on Human Rights. So what does this mean in practice? We've had a couple of examples from Scotland. They, up in Scotland, using the government, using their own parliament, has actually created acts of their parliament that don't comply with the legislation, the human rights rules. So they've passed 2 of these things, were passed and were supposed to start, and immediately they were challenged in the courts. People went to court and said, this act, as obviously the famous one is the Gender Recognition Act, just doesn't comply with the European Convention on Human Rights. And a court looks at it relatively quickly and says no. So the whole thing is void. It never comes into effect. Whereas if Westminster did that, it would come into effect and you'd have to go through a court process to challenge it later. But for a while, it would be in effect. So this is a very powerful control over those 3 provincial governments. And in practice, what it means is we have another awful piece of legislation coming in Scotland. We have this hate crime legislation, which has passed through the Scottish legislative process. And in fact, our dear King has actually signed the piece of paper saying that it should be fully come into effect. But they haven't done anything about it to put it into effect. And as soon as it comes into effect, it'll be very difficult for them to operate it, because you would understand as a policeman, if I start acting on this under the powers that are given to me by this act, it's going to be challenged. It might take several months, but it's going to be challenged and declared void. So if it's declared void in December and I arrested you in June and did various things to you, it'll turn out that I had no legal power to have that, to do that. Everything I did to you in June was outside the law. So therefore, even though there is some delay, of course, this is a considerable break on those 3 parliaments, governments in Northern Ireland, Wales, and Scotland actually doing these things. They know they are subject instantly to control under human rights. Now, I'm sure people are following enough of these stories to know that we have an awful lot of problems with Scotland, Northern Ireland, and Wales. They're all areas of the UK, their parliaments, their government, who are strongly captured by these transgender ideas. That's where it's really biting and being pushed in the UK. So we have to remember, therefore, that the fact that we can now use these human rights from the European Convention in our courts has saved our bacon, vegan or otherwise, in several occasions in the UK, because we've been able to shut down Scotland, Northern Ireland, and Wales going way ahead on all of this and introducing the most appalling laws. So, my final point today is that is now the situation that still stands. We have the Human Rights Act, and we have this settlement for the 3 sort of provincial areas. And at the moment, they're providing us with a lot more protection than we had before. You know, when you had to drag yourself for 7 years off to the court in Strasbourg, and because you can use these rights in our courts, and they're very, very tough on the governments in Northern Ireland, Wales, and Scotland. So my point is obviously that we need to stick to this as much as possible. You will no doubt be seeing occasionally, as you follow, you know, legal and political affairs, that people jump up periodically and say, we need a Bill of Rights. And then a lot of technical discussion follows. Now, this is intended to get rid of the Human Rights Act and replace it with a piece of legislation in the UK covering the whole UK, which is going to get rid of the Human Rights Act. It's often dressed up as, you know, an improvement. Believe me, it's not an improvement at all. The only people who are pushing to get rid of the Human Rights Act and have what they will, you know, generally all these proposals are badged Bill of Rights, do not wish anybody any good. They are not trying to do this to improve our human rights, to improve our ability to use these rights. Because as you say, you can be given rights, and then there can be quite a lot of difference and difficulties of how do they actually operate? How do I use them? Like when we couldn't go to our own local courts. So we're coming into a year, you know, when there are going to be elections in the UK. At the moment, the latest proposals for bills of rights being pushed by the government, the Tory government in Westminster, have been dropped again. But there are people who don't like human rights, who are always behind the scenes, or then occasionally they pop up, you know, going on and on about bills of rights. Do not listen to them. We must fight for our existing arrangements. And just one thing for point of information, so Bill of Rights, well, what's that? It's just trying to make it sound posh. A Bill of Rights would be a normal act of Parliament, an act of the Westminster Parliament. And acts of the Westminster Parliament, we don't have a constitution. You can't sort of make them secure. You know, you can't sort of dig them in. Any act of the Westminster Parliament can also be changed. So they would be working to remove our Human Rights Act in Westminster and put in another piece of legislation, which is Act of Parliament, but called something posh, like a Bill of Rights. And this is all designed to try and reduce our access to the rights we have. So that is my little bit of history and just a little bit of reminder to everybody of these things that have happened over the last 26 years ago. And this is my warning to bring things up to date. We've got lots of other legal issues going on, but I thought it was useful. Don't get sidetracked by anybody who starts to talk about getting rid of the Human Rights Act and putting in a Bill of Rights. And remember, any sort of fundamental constitutional change like that would just open the door to start saying, well, why don't we change the way we do with human rights in the devolved areas? This gives us an opportunity to mess around and reduce the protections that people have in Scotland, Northern Ireland, and Wales while we're pursuing this project. So I think people have got the point. And so my final comment is, next week I will do another very short but sort of similar, let's remind ourselves and let's get the history clear, and let's look clearly at what's happening about CEDAW, the UN Convention on the Rights, on the elimination of discrimination against women, just so that people are clear about what's actually going on. So thank you very much.